Good morning, everyone. My name is Judge Jackie Powell, and we're in first appearance court this morning. Today in the courtroom, I have a representative from the State Attorney's Office, Mr. Eric Linder. I have an attorney from the Public Defender's Office, Mr. Brian Reedy. And also in the courtroom, I have representatives from pretrial supervision, confinement status. I have the clerk's office represented, and we have a bailiff in the courtroom. Today is not your trial day. Today is the first time you come up, and I'm going to tell you whether there is probable cause to detain you based on the information that I have read, all of which I've read this morning. If I find probable cause, then I'm going to determine release conditions. For some of you, not all of you, some of you with a misdemeanor case, you may be able to resolve that case today. I'll be able to hear the offers from the state and relay those to you. As I said, today is not your trial date, and everything in this courtroom is being recorded. So you want to make sure that you speak with your attorney before you speak on the record about anything concerning your case. And so with that said, I'm going to call in order of the docket, because we have a big docket this morning. When I call your name, if you will just come up to the podium. If I have private attorneys in the courtroom, if you can speak to the bailiff and let them know what page so we can try and locate your case as we go through, because as I said, I do have a big docket this morning, and it's not easy for me to go by the docket. I have to actually find the paperwork. So let me start this morning with Nestor Nino. Good morning, Mr. Nino. You're before the court today, sir, for me to let you know that there's an out-of-state felony hold. You should be going before the extradition court either next Tuesday or Thursday. Good luck, sir. Jacqueline Bendel.
Yes, ma'am.
No problem, Your Honor. Good morning.
Good morning.
Good morning.
I had Miss Bendel yesterday.
Yes, I'm still here.
This is showing that there is a capias and a municipal ordinance matter, but
well, Judge, in light of the fact that
I thought we resolved all
she
of
had
those.
misdemeanor charges yesterday, I'd be more than happy to stand in and advise the court she'd like to just get the same time served that she got yesterday and resolve this municipal.
I was almost sure that that's what we did.
Yeah, apparently this was kind of, nobody knew about it. Maybe until they tried to release her.
Okay.
It might have come up then.
All right, Ms. Bendel, in light of the fact that you were here yesterday, we thought that this was resolved. I'll give you the same sentence, adjudication, and time served. Good luck, ma'am.
Thank you.
All right.
So does that mean I'm getting out today?
If there's nothing else
I don't think there's
holding
anything
you.
else holding you, so
Thank you.
good luck.
Shibra Stevens.
Main Judge.
Your present, Judge, at Maine?
Good morning, Ms. Stevens. You're before the...
Oh, municipal ordinance, Judge.
Yes.
Judge, just passing also along a message. I know Mr. McLawrence called me and informed me he's running behind.
All right, so Ms. Stevens, I will recall you when your attorney gets there, okay? This is who she's here on. We're gonna go out of order. McCoy, Lauren Myrick McCoy. Private attorneys in the courtroom.
Judge, your present.
I'm sorry? It's a female. Lauren Myrick McCoy. Ms. McCoy,
Hello.
good morning. You're before the court today for 5 counts of child neglect without great bodily harm. I did read the probable cause affidavit. I do find probable cause. Mrs. James, you wish to address the bond issue?
Yes, Judge, I would. Ms. Myrick McCoy has no priors. She has strong ties to the community. She's got a strong family unit. It's actually her family who contacted me about this case when I was here yesterday and this morning. I'm going to ask for the court to release Ms. Myrick McCoy on pretrial as to all counts with no contact with the children that are not her biological children. I'm going to ask the court for supervised contact with her biological children, and additionally, and order that she follow the DCF case plan that is in place or that will be in place shortly.
Your Honor, I spoke about this matter with counsel this morning. She does have no criminal history. I'm going to be requesting $1,000 bond on each count based on the allegations. Your Honor, at this time, until there can be a more thorough hearing in front of the assigned judge, I'm going to be asking for no contact with any of the alleged victims.
What's the name of the company you work for?
All right. Often when you read these probable cause affidavits, you know, there are great concerns. And so I am going to impose $1,000 bond on all counts. And if Ms. Myrick McCoy is able to post her bond, I'm also going to add standard pretrial release. No contact with any other minor. Yes, supervised contact with her own children.
Okay.
Okay?
Thank you, Your Honor.
Thank you.
Thank you.
Excuse me.
Jerome, is Edwards yours, Mr.?
Oh, you called me?
Okay. On this PC, Marcus Jerome Edwards, I was missing, I think, the last page or the second page.
We all are, apparently.
Yeah, we're definitely going to list everything after the first.
Okay.
So I'm just checking with. No. Okay. Your Honor, can I have a moment to speak to Mr. Lewis?
Sure. Bridget Marie Sorling.
Her bond was posted.
Ms. Sorling's bond was posted.
No problem, Your Honor.
North Broward. Good morning, Ms. Sorling.
Good morning.
Ma'am, you're before the court for municipal ordinance KPS.
Yes, ma'am.
The court does find probable cause, and I've been advised by confinement status that your bond has been posted.
Okay.
Okay, good luck, ma'am.
Thank you.
Shashuki Olivia Johnson.
Ms. Johnson, Sashuki Olivia is here, present Judge Amain. She's approaching.
Good morning, ma'am. You're before the court this morning for one count of petty theft. The court does find probable cause.
Judge, I spoke with Ms. Johnson. Considering, my understanding is she has a clean record. This is a nonviolent offense. She's looking forward to having her day in court and disputing these allegations. Having said, Judge, I'm going to be asking the court if the court would be inclined to ROR Ms. Johnson this offense.
What, does Ms. Johnson have any priors?
I just need one moment, Your Honor. I was speaking to Mr. Lewis. Who is this, Your Honor?
Shashuki Johnson. Last name is Johnson. Shashuki Olivia Johnson.
For her paperwork.
Petty theft.
No, I don't have an objection.
Okay, then I will ROR Ms. Johnson on this case.
Thank you, Judge.
Good luck.
Your Honor, I think we can go back to Mr.
Mr.
Edwards.
Lewis?
Judge, if we could readdress Marcus Edwards back on page 15.
Okay.
Obviously, the court probably is not in a position to make a probable cause finding without the whole affidavit. But we
Right.
can go ahead, talking to the state, and agree to a $3,500 bond. Assuming he can make that overnight. If not, then we'll readdress it. And the rest of the
Your
affidavit.
Honor, that would be fine. The only thing I would ask, Your Honor, is that whatever, if the court is inclined to set a $3,500 bond, that it be without prejudice, depending on what information the state, assume the state is able to come back.
Yeah, Marcus Edwards.
Okay. Mr. Edwards, good morning.
Morning.
Okay, sir, you can see your attorney in the courtroom, right?
Yes.
All right, so you're before the court today for a count of possession of a weapon by a convicted felon and disobeying a stop sign, which is not for magistrate. Your attorney has spoken to the state, who has no objection for me to impose a bond of $3,500 without prejudice, okay?
Yes.
All
Yes,
right,
ma'am.
all right, sir, good luck.
Thank you, Judge.
You're welcome, Mr. Lewis.
This way.
I'm sorry. 3,500. Yes.
I just need you to sign over here.
All right. Terry Levette Edens.
Medical reset, Your Honor. She's a medical reset.
Hold on just a moment. I'm sorry, do I have what?
Natalie Johnson?
I don't know.
That was from my office, there was no paperwork.
I don't have,
That's what our office told us. Oh, but she only got.
Terry Levette Edens,
She's a medical reset, Your Honor.
okay. Tereska Bryant.
Lord Brown.
Good morning, Miss Bryant.
Good morning.
Ma'am, you're before the court on one count of resisting officer without violence. Counts 2, 3, 4, 5 are felony capias. Counts 6, 7, and 8 are felony violation of pretrial. The court does find probable cause as to count 1, which is the only count for magistrate. Your bond is $100, and my notes indicate that you should be going to court on February 4th to your felony division. Good luck, ma'am.
Good everybody. Is that it?
Nadine Guzman. Nadine Mary Guzman.
She's approaching, Judge. She's here at Maine.
Okay. Good morning, Ms. Guzman.
Good morning.
Ma'am, you're before the court on 7 counts of distributing or delivering, 1, 2, 3, 6, and 7 are distributing or delivering cocaine. 4 and 5 are distributing or delivering heroin. The court does find probable cause. What are Ms. Guzman's priors?
2013, possession of cocaine hydromorphone with a VOP. 2012, possession of cocaine with a VOP. 08, burglary of a conveyance with a VOP. Loitering and prowling 05. She went through drug court in 01 for possession of cocaine.
All right. Does Mr. Romero, do you wish to be heard?
Not at this time, Judge.
Okay, then Ms. Guzman, on all counts, your bond is $2,500, and I will leave it at that. Good luck, ma'am. 2500, 2,500 each. Kissy Cola Wilson.
Miss Wilson is here present, Judge, and she is approaching. Come on up, ma'am.
Ms. Wilson, good morning. You're before the court today on 2 counts of distributing or delivering cocaine. The court does find probable cause. Your bonds are $2,500 on each count. Good luck.
Judge, regarding Miss Wilson, I do wish to be heard. And speaking with her, I did tell her what the monetary amount and the bond is, and she informed me, unfortunately, she's not going to be able to afford it, and there's no one I can contact on her behalf that will be able to afford it. She's 40 years old, been here her whole entire life. At this time, she's looking for stable employment, but what she does is she does hair on the side, and that's what helping her survive at this time. She lives in Pompano Beach with roommates where she rents a room and where she's been residing there for the past 2 years, and from what she informed me, no one that lives there is going to be able to help post her monetary bond. Now, she did advise me she has a record, but she's been several years clean. Having said that, Judge, I'm going to be asking the court to consider releasing Miss Wilson on pretrial release.
I'll put her on a level 2 with random testing.
Thank you, Judge.
All right.
Necessary?
I'm sorry?
No bond necessary.
No, no bond. Yes. Chastity Wilson.
Miss Williams is here present.
I'm sorry, Chastity Williams.
She's here present, Judge.
Ms. Williams, good morning. You're before the court for 1 count of grand theft, and then there's a traffic capias matter. The court does find probable cause.
Judge, Miss Williams informed me. I'm sorry.
Go ahead.
Ms. Williams did inform me, besides these two matters that are on the docket, she has a clean record. She's been here her whole entire life. I realize count two is a capias, it's a failure to register a vehicle. From what she informed me, she didn't know the court date, so she found out there was warrant, and she went actually, from what she told me, this Monday to the clerk's office to reschedule a date, to get a hearing date in front of her and judge to get that warrant or that capias lifted. Judge, if she has no prior record and hopefully Odyssey reflects something as far as her having rescheduled the date, I'm going to be asking the court to consider an ROR on her behalf.
I see no criminal history, Judge.
Okay, with no prior criminal history, Ms. Williams, I will ROR you on this count. Good luck.
Thank you, Judge.
Yes,
And for the record, Odyssey does seem to support her claim.
that she has a reset date. Thank
There was
you.
a defendant filed a request form on January 28th.
Thank you, Mr. Reedy. I'm sorry? ROR on both counts. Yes. Destiny Barnes,
Medical reset, Your Honor.
okay. Brianne Joseph,
North Broward, she's in courtroom 4810 downtown.
okay. All right, will do. John Alexander Maher,
Bonded, Judge?
thank you. Jose Santiago.
North Broward.
Good morning.
Good morning, Mr. Santiago.
Good morning.
Sir, you're before the court. Count 1, DUI, alcohol or drugs, second offense, and count 2, DUI with property damage. The court does find probable cause. This one.
Judge, Mr. Santiago indicated to me that he's represented by private counsel, Michael Braxton. I left a message for Mr. Braxton. I have not heard back as of yet. Maybe we could put it on recall for a brief period. Let me see if I can get a hold of him.
Okay. Mr. Santiago, there's indication that you have a private attorney, Michael Braxton. So I'm going to recall your case. We'll see if Mr. Braxton shows up. Okay?
Okay.
All right. John Arthur Bailey.
Yes, sir.
He's approaching, Judge. He's here at me.
Mr. Bailey, good morning.
Morning.
Mr. Bailey, you're before the court today for 1 count of touch or strike battery and 2 resisting officer without violence, and the court does find probable cause.
Judge, in speaking to Mr. Bailey, unfortunately, no one's going to be able to afford to post his monetary bond. So, Judge, considering these are misdemeanor offenses, we're going to be asking the court to consider releasing Mr. Bailey on pretrial release.
Your Honor,
Wait.
Your Honor, the state is going to be opposing outright release to pretrial. Mr. Bailey has been before this, through this division numerous times over the past few months. He's ROR'd on a burglary conveyance right now where he went into a rehab center and started a fire in the emergency exit where the fire exits. The state has not made a filing decision on that case. He pled out last year a criminal mischief where he damaged a window in a McDonald's. He pled out last year a criminal mischief where he spray painted or did derogatory statements about at an AA place where AA meetings are held. He had a trespass last year against his estranged wife, where he was repeatedly told not to go to her home, and he went there anyways. And now today, he stands before the court after emptying a trash can at a 7-Eleven on the floor, on the ground outside, when he was confronted by a store employee, a female store employee. He grabs her by the collar of her shirt and kicks her in her leg.
The court does find, thank you, the court does find probable cause. As to count 1, the bond is going to be $1,000, and if Mr. Bailey is able to post his bond, he's also going to be on standard pretrial release. No contact with Rochelle Gordon, and no return to the 7-Eleven at 14 North Federal Highway in Pompano Beach. Good luck, sir. Gregory Louis Charles.
Judge, he's posted his bonds on the local chart.
Okay. Mr. Louis Charles, you're before the court today for 2 counts of traffic KPS, and then counts 3 and 4 are out-of-county holds. I've been informed that as to your local cases, that your bonds have been posted, but you have no bond hold on one of the out-of-county holds. So good luck, sir.
When you have a chance, I don't know if the if the court's aware, Nathalia Johnson on page 2 is still here.
Is what?
Nathalia Johnson on page 2.
Yes.
She's still here. I don't know if if the paperwork maybe was accidentally.
I was told that she's not, that I have no paperwork for her.
Oh, Nathalia Johnson. Okay, is that going to be reset for this afternoon so I can tell?
Confinement, is that right? Nathaniel, what's her name? Nathalia Johnson. That's the one you asked me about. I have no paperwork for her.
They're gonna put her on second.
On the afternoon. She'll be on the afternoon, Mr. Romero.
Thank you. I'll let the PM know.
Okay. Tendai Murape.
No problem, Your Honor.
Good morning, sir.
How you doing, Judge?
I am doing well. You're before the court today for 1, obstruction of highway, and then there are 2 municipal ordinance matters. Would this be Mr. McLawrence? You're walking in at a good time for me to ask you. Tendai Murape, is that one of yours? No, it's not.
Stop trying me.
All right. Mr. Murape, the court does find probable cause, and your cases are, it's Pompano Beach. You did tell me that.
Judge, I think that the misdemeanor in this case is intertwined with the municipal ordinances, so I'd be happy to represent Mr. Murape. He's indicated to me he'd like to resolve everything today if possible.
Oh, you did speak with him.
I did.
All right. So, Mr. Murape, I understand that you wish to resolve your case today?
Yes, Judge.
All right. Do you have any priors on Mr. Murape?
Yeah, he's been through, Your Honor, but mostly
Some municipal ordinance matters?
lower level offenses.
Okay.
I was going to offer an adjudication time served on 1.
Okay.
Is that what you would like to do, Mr. Murape, adjudication time served?
Yes.
Okay, sir, please raise your right hand. Do you, sir, affirm to tell the truth?
Yes.
You can put your hand down, sir. Mr. Murape, do you understand the proceedings that you're in today?
Yes, Judge.
And do you need more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No.
Do you understand that by taking a plea today, you're giving up your right to go to trial?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you're not a U.S. citizen, that taking a plea could subject you to immigration changes or deportation hearings?
Yes.
Mr. Marape, what plea do you wish to enter today?
No contest.
All right, sir. I accept your no contest plea. I find that it's freely and voluntarily given, and I sentence you to adjudication and time served on all 3 counts. And I will give you 6 months to pay your court costs. Good luck, sir.
Thank you.
Good luck.
Thank you. Good luck.
2 days. Now you go back in there. Thank you.
Wilkin Jean Philippe.
He's in North Broward, Judge. He'd like to resolve these matters today if possible.
Okay, good morning, sir.
Good morning, Your Honor. How you doing?
I'm doing well. You're before the court today for trespassing on occupied structure or conveyance, and there's a misdemeanor KPS matter. I do find probable cause, Mr. Jean Philippe. Your attorney tells me that you wish to resolve your case today.
Yes, ma'am.
Does the state have an offer?
Your Honor, the offer to resolve would be an adjudication, time served on each. My concern is it makes reference in the report that Mr. Jean Philippe was out on pretrial, I believe, with the GPS. Was it with the GPS? His confinement number? One moment, Judge. Because it does appear he's on pretrial with the GPS.
Okay. So, I'm sorry.
The only thing I was going to request is, the offer's still in adjudication, time served, and I don't know if I can inquire of pretrial. If for some reason he's released before the warrant's signed or served on him, will the jail put the GPS monitor back on him? Okay, nothing further.
All right, Mr. Jean Philippe, before the court today, as I informed you, was the trespassing on the capias of the misdemeanor capias. The offer is adjudication and time served. Do you wish to resolve the cases with that offer today?
Yes, Your Honor, please.
Please raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down and state your name for the record.
Jean Philip Wilkin.
Okay. Wilkin is your last name?
Yes, ma'am.
All right. I have it backwards on my paperwork. Mr. Wilkin.
It's backwards all over.
Oh, okay. Mr. Wilkin, do you understand the proceedings that you're in today?
Yes.
Is anyone forcing you to resolve your case?
No.
Have you had enough time to speak with your attorney?
No.
You have not had enough time to speak with your attorney? You need more time?
Do you need to talk to me again?
I'm okay. I need to resolve my case.
Do you need any more time to talk to me? I thought we pretty well discussed everything earlier, but if you want more time, you can have it.
We're good.
Okay. All right. Do you understand that if you take a plea today, that you're giving up your right to go to trial? And have you ever been treated for mental or emotional illness?
No.
Mr. Wilkin, do you understand that if you're not a U.S. citizen, by taking a plea today, you could face immigration changes or deportation hearings?
Yes.
What plea do you wish to enter today?
No contacts.
All right, then I accept your no contest plea. I find that it's freely and voluntarily given. And I sentence you to adjudication and time served. Mr. Wilkin, no return to the Cambridge Square apartments.
Okay.
All right, and I'll give you 6 months to pay your court costs. Good luck, sir.
Thank you.
All right. Terrence Terrell Holmes.
Mr. Holmes is here, present judge at Maine.
Okay. Mr. Holmes, good morning. You're before the court today for resisting officer without violence. The court does find probable cause. What does Mr. Holmes wish to do?
Judge, in speaking to Mr. Holmes, he wishes to resolve this case today.
State, do you have an offer for Mr. Holmes?
Yes, Judge. The offer would be time served.
Mr.
Judge,
Holmes
he wishes to accept the state's offer.
Okay, Mr. Holmes, will you please raise your right hand?
You're right.
The other one. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Can you state your name for the record?
Terrence Terrell Holmes.
Mr. Holmes, do you understand the proceedings that you're in today?
Yes, ma'am.
And, sir, have you had enough time to speak with your attorney?
Yes, ma'am. He did a good job.
Is anyone forcing you to resolve your case today?
No, ma'am.
All right. Do you understand that by taking a plea today that you're giving up your right to trial?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, you could be subjected to deportation proceedings?
Yes, ma'am.
Mr. Holmes, what plea do you wish to enter today?
No contest.
Then, sir, I accept your no contest plea. I find that it's freely and voluntarily given and sentence you to adjudication and time served. And I'll give you 6 months to pay your court costs.
Thank you.
Good luck, sir. All right. I'm going to go out of order a little. If somebody will tell me what page is Michael Jonathan Lockhart. There's an attorney here on his behalf. Good morning.
Good morning, Your Honor.
On page 16, it's Michael.
Have an attorney?
Good morning, Mr. Lockhart.
Good morning.
Sir, can you see your attorney on the screen?
Yes, ma'am.
All right. You're before the court today for 1 count of DUI, alcohol, 3rd offense within 10 years, 2, refusing to submit to DUI, 3 and 4 not from magistrate. They're traffic infractions. The court does find probable cause. Sir, can you?
Your Honor, Antonio Quinn on behalf of Mr. Lockhart. Just with regard to the 3rd DUI, I do take issue actually with the probable cause. There's no reference to him having any priors in the probable cause affidavit, but even more importantly than that, I have represented Mr. Lockhart before, and I know he's been arrested for DUI twice in the past, but the 14 case that he was arrested on, he was not convicted on, so he's only got 1 prior DUI conviction.
Okay. So then I'll find probable cause as to DUI.
As to a 2nd DUI, which would be a misdemeanor as opposed to a felony. The 3rd DUI within 10 years would be a felony.
Can I have the driving record of Mr. Lockhart?
For the record, Your Honor, the case I'm referring to is the 14-3208 MU-10A. That case resolved eventually by reckless driving. However, he was convicted in the 16-9819 case, but that's the only prior DUI.
On the, which one? Because I've got a 16 that he was,
The 16 he was
found
convicted on,
guilty.
that was the one case that he was found guilty on, but there was also a 14 that he was arrested on that was resolved via a reckless driving. I believe he got a withhold on the reckless driving.
That's what the driving record supports. Do you have anything? All right, so based on the driving record, I find probable cause for 1st DUI.
Well, no, it's the second DUI.
The second DUI, I'm sorry, because there was a previous conviction, so it's the second DUI. All right, and the bond is $1,000 on count one, and I will not impose a bond on the second count.
Thank you very much, Your Honor.
All right. Thank you, Mr. Quinn.
Thank you.
I have to cross out the third. It's not gonna come back and say the third, right? Because I found PC for the second.
Right, and that's what the court
Right,
is gonna write.
the state of change it by, change it.
All right, I'm gonna put DUI second. PC found. You're welcome. Good luck. You have cases, Mr. McLawrence?
Yes, Judge.
Did you tell us which ones so we can find them?
One of them is on recall, Judge. It should be, it's Shebra Stevens.
Yes, I do have Shebra Stevens.
She's on page 2 of the docket. And the other one is Terrence Henry. He's on page 18 of the docket, and he has some accompanying felonies.
Okay, we can recall Shebra Stevens.
Good morning, Your Honor.
Good morning, Ms. Stevens. I'm recalling your case now that your attorney is here. The court does find probable cause on the municipal ordinance, 3 counts of the municipal ordinance matters. Have you had enough time to speak with your attorney?
Yes, Your Honor.
Mr. McLawrence, what does she wish to do?
Judge, she wishes to resolve these matters. I spoke with her, Judge. I do take some issues with some of the things that are in the probable cause affidavit. Nonetheless, she indicated to me that she did not want to fight it. She just wanted to resolve these matters.
John Ball.
All right. What kind of record does Ms. Stevens have?
She's been through a lot.
The trespassing, the municipal ordinance
Yeah,
matters?
low-level type matters.
All right. And I will offer Ms. Stevens adjudication and time served, if that's what she wants to do.
That's what she would like to accept, Judge. Is that what you want, Ms. Stevens?
Yes, sir. Thank you.
Okay, Ms. Stevens, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Ms. Stevens, do you understand the proceedings that you're in today?
Yes.
You understand everything that's going on?
Yes, Your Honor.
Is anyone forcing you to resolve your case today?
No, ma'am.
And do you understand that you're giving up your rights for this case to be investigated and hearings to be heard and to go to trial? Are you waiving that right?
Yes, Your Honor.
Have you ever been treated for emotional or mental illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that taking a plea could subject you to deportation or immigration changes?
Yes, I am aware of that.
And what plea do you wish to enter today? Guilty or no contest?
No contest.
I accept your no contest plea, Ms. Stevens. I find that's freely and voluntarily given. I sentence you to adjudication and time served, and I'll give you 6 months to pay your court costs. Good luck.
Thank you.
You're welcome. What's the other one, Mr. McLawrence?
Judge.
Oh, okay, thank you. Terrence Henry?
Yes, Judge. He's in the main jail. He's on page 18 of the docket.
Thank you very much, Madam Clerk. Mr. Henry, good morning.
Good morning, Your Honor.
Mr. Henry, you're before the court today. There's felony capias, 2 of them, and then there's a misdemeanor capias. So the count 1 is for magistrate. I believe that's the one that Mr. McLawrence represents you on. But the other 2 felony matters that are not for magistrate, you have court dates next week on both of them.
Terrence Henry, page 18.
Terrence Henry.
Judge, in speaking with Mr. Henry, he knows that his 2 felony matters, he's being held here, no bond. And he is pretty knowledgeable about sentencing score sheets. Him and I discussed that, and he realized that resolving this case would add 0.2 points onto his felony sentencing score sheet. And he told me that's what he wants to do. He doesn't want to get held up in after he resolves his felony by this matter. So he would like to know if he could resolve this case here today. When I say this case, Judge, I mean count one.
Count one.
Loitering and prowling.
Mr. Henry, you have had enough time to speak with your attorney.
Yes, ma'am.
And you understand that if you resolve this municipal ordinance matter, that it could add points to your score sheet.
Yes, ma'am.
And you knowing that, you still wish to resolve this case today?
Yes, I do.
All right. And I'll do adjudication and time served, if that's what he wants to do.
That's what he wants to do, Judge. Is that what you want to accept, Mr. Henry?
Yes, sir.
All right, Mr. Henry, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Put your hand down, please, and state your name for the record.
My name is Terrence Henry.
And Mr. Henry, do you understand the proceedings that you're in today?
Yes.
And have you had enough time to speak with your attorney?
Yes.
You understand that you're giving up your right to go to trial?
Yes.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Are you under any medications today that would affect you making a decision?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that you could be subjected to deportation proceedings?
Yes.
What plea do you wish to enter, Mr. Henry?
No contest.
I accept your no contest plea on the count only of loitering and prowling. I find that the plea is freely and voluntarily given, and I sentence you to adjudication and time served. I'll give you 6 months to pay.
Judge, is there any way to make it 6 months upon release?
6 months upon release, because you're still going to be in custody on the felony matters. So.
I already know, Your Honor.
Okay, good luck, sir.
All right, thank you. Have a good day.
You're welcome.
Mr. Day, I just want you to know I did call your mom and I left a message for her. Kareem?
Michael Allen Hinch. Mr. Hinch is before the court today for one traffic KPS and then 3 misdemeanor KPS. The court does find probable cause. What does Mr. Hinch wish to do?
Judge, in speaking with Mr. Hinch, he wishes to resolve this matter today.
These are all, let me make sure, they're all state?
No, two
No,
and three
there's
are
one,
MOs.
there are 2 municipal ordinance matters. So, Mr. Hinch, you are entitled to an attorney. On the first count, it's a state case, so the public defender's office is representing you. But the other 2 counts are municipal ordinance matters, and there are no attorneys in the courtroom for the municipal ordinance matters. So here are your options. We can attempt to get that attorney here, or you can resolve the case with help from the public defender's office on those other 2 counts if you so wish.
I'd like to resolve it, Your Honor.
All right. As to the state matter, state?
In adjudication time served.
All right. Mr. Hinch, the offer from the state is adjudication and time served. I will extend that offer on the municipal ordinance matters. I'll extend the offer of withholding court costs. So it's adjudication and time served on one, and then withholding court costs on the other 2. Do you wish to resolve your case in that manner?
Yes, ma'am.
All right, sir. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
Then you can put your hand down, and please state your name for the record.
Please state your name.
Michael Hinch.
Okay, Mr. Hinch, do you understand the proceedings that you're in today?
Yes, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Have you ever been treated for emotional or mental illness?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
I do, ma'am.
Then, knowing that, Mr. Hinch, what plea do you wish to enter today?
No contest.
Mr. Hinch, I accept your no contest plea. I find that it's freely and voluntarily given. As to count 1, you're sentenced to adjudication and time served. On counts 2 and 3, the sentence is withhold adjudication and court costs. I will give you 6 months to pay your court costs, sir. Good luck.
Thank you.
You're welcome. Leonard Farquharson.
He's approaching, Judge.
Good morning.
Good morning.
You're before the court today for a misdemeanor KPS on a prostitution charge. The court does find probable cause.
Judge, in speaking with Mr. Parkinson, how do you pronounce your last name? I'm sorry. He wishes to ask the court if you would consider resolving this matter today, Judge.
Okay, does the state have an offer for Mr. Farquharson?
One moment, Your Honor. Would be adjudication, time served, HIV test.
Okay.
Wishes to accept that.
Okay, Mr. Farquharson, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Then you can put your hand down and state your name for the record.
Leonard Parkinson.
And Mr. Farquharson, do you understand the proceedings that you're in today?
Yes.
Have you had enough time to speak with your attorney?
Yes.
Is anyone forcing you to resolve your case today?
No, ma'am.
Do you understand that by taking a plea today that you're giving up your right to go to trial?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Yes.
Knowing that, Mr. Farquharson, what plea do you wish to enter at this time?
No contest.
Then I accept your no contest plea. I find that it's freely and voluntarily given. I sentence you to adjudication and time served. You must take an HIV test. You don't need to surrender the results, but you need to show them receipt that you did take the test. Do you understand? I'll give you 6 months to pay your court costs. Good luck. Rodney Eugene Vinson.
Your Honor, Mr. Vinson's employer is present.
Mr. Vinson's employer, ma'am, you can come to the front. Good morning, Mr. Vinson. You're before the court today for a count of operating without a valid driver's license. And then there are 2 misdemeanor capias. One of them is a municipal ordinance matter. Oh, 2 of them are municipal ordinance matters. What does Mr. Vinson wish to do today?
Judge, and speaking with Mr. Vincent, he wishes to resolve this matter today.
On the state charge, the state, do you have an offer?
Time served.
All right, ma'am, thank you for being here today. Is there something you wanted to let me know, or?
No, he's a good worker. He just, I need his help. I need him to come home.
What kind of work does he do?
Landscaping.
Okay. All right. Well, Mr. Vinson, you have support in the courtroom. The offer is adjudication and time served from the state. I will extend the same offer on the municipal ordinance matters today, if that's what you wish to do.
Yes, ma'am.
Okay. Now, Mr. Vinson, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down and then please state your full name for the record.
Rodney Eugene Vincent, ma'am.
And Mr. Vinson, do you understand the proceedings that you're in today?
Yes, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
Do you understand that you're giving up your right to go to trial by taking a plea today?
Yes, ma'am.
Is anyone forcing you to do that?
No, ma'am.
Sir, have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, you could be subjected to deportation or immigration changes? Do you understand that?
Yes, ma'am.
Knowing that, Mr. Vincent, what plea do you wish to enter on these 3 counts before the court?
No contest, Your Honor.
Mr. Vincent, I accept your no contest plea. I find that it's freely and voluntarily given, and I sentence you to adjudication on time served on all 3 counts. I will give you 6 months to pay your court costs. Good luck, sir.
Yes, ma'am. Good luck, sir.
Thank you, ma'am.
You're welcome. Thank you. Kevin Puryear. Good morning, sir. Mr. Puryear is before the court today for an open container of misdemeanor KPS. The court does find probable cause. Mr. Puryear, do you wish to resolve your case today? You gotta press the button in front of you there so I can hear you. All right, that's good.
Okay.
All right, Mr. Puryear, this is a municipal ordinance matter, and so we don't have an attorney representative here for the city of Pompano Beach. So I need to let you know that you do have the right to an attorney. If you wish, we can try and get an attorney for you, or if you want to resolve the case today, my offer to you is a withhold adjudication and court costs.
I would like to resolve the case today, Your Honor, by pleading no contest.
Okay, know that I only have this one case before me. I don't know if there's anything else holding you. I don't know if you have anything else pending. Do you understand that?
Yes, ma'am.
All right, Mr. Puryear, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Then you can put your hand down and state your full name for the record.
I didn't hear you.
State your name for the record.
Kevin Wayne Puryear.
Mr. Puryear, do you understand the proceedings that you're in today?
Yes, ma'am.
And do you understand that by taking a plea today that you're giving up your right to go to trial?
Yes, ma'am, I understand that.
And is it your desire to resolve this case without further help from any attorney today?
Yes, ma'am, that's my desire, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that by taking a plea, you could be subjected to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Puryear?
No contest, Your Honor.
I accept your no contest plea. I find that it's freely and voluntarily given and sentence you to adjudication and time served. Good luck.
Okay, thank you, ma'am.
Good luck, sir. Daryl Shane Hughes. Okay. James Francois. Mr. Francois, good morning. Sir, you're before the court today for criminal mischief. The court does find probable cause.
He's got a no bond hold on an armed burglary and $30,000 in other bonds.
Right,
Okay,
Judge, I'd
so
ask you to leave the bond.
The bond is $500. Good luck, sir. Lakody D'Angelo McCartney.
Paul Ryan.
Yes, ma'am. Yes, ma'am.
Mr. McCartney, good morning.
Good morning.
Sir, you're before the court. It's a felony capias. It's a change of charge.
And he's got $35,000 in other bonds.
Okay.
I'd ask the court to leave the bond where it is.
All right, so, Mr. McCartney, there's a change of charge, a possession of utilone. Your bond is $1,000. Good luck, sir. The court finds probable cause.
Ma'am.
Yes, sir.
May I have more time to speak to my attorney?
Your attorney?
Yeah, I'll have your attorney come and speak to you at the jail, Mr. McCartney.
All right.
Okay, sir. Joshua Devin Spells.
Is here present Judge at Maine.
Mr. Spells, you're before the court today for, it's a felony KPS, resisting without violence. The court does find probable cause. Your bond is $100. And my notes indicate that you should be before your felony judge on February 5th at 9 a.m. Good luck, sir. Michael Richardson.
He's approaching, Judge.
Mr. Richardson, good morning.
Good morning. How you doing?
I'm doing well. Mr. Richardson, you're before the court today on one count of grand theft. The court does find probable cause.
Your Honor, Mr. Richardson has bonds totaling over $55,000 in his other charges.
All right. Mr. Richardson, I'll leave your bond at $1,000 on this count. Good luck, sir. Jenard Murphy.
All right, ma'am.
Thank you. Mr. Murphy, good morning. Mr.
Good
Murphy,
morning, Mom.
you're before the court today. There's an KPS ad charge for possession of firearm by a convicted felon. Was there a bond on a?
It's an ad charge. He's got over $30,000 worth of bonds on one case with the top count being an armed burglary. He's also being held court-ordered no bond on another case where the top count's an armed burglary. I was going to request a $5,000 bond on this count, Judge.
All right. Mr. Murphy, the court does find probable cause. As to this count, I'll set a bond at $1,000 on this count.
How you find, man, can I say something?
Yes, sir.
How could you find a probable cause and they never got a firearm on me? I have no.
Oh,
I never got caught with a firearm.
Well, you don't want to talk about your case, and you do want to speak to your attorney. They'll be able to file the proper motions, okay?
Yes, ma'am.
All right, sir. Kareem Day.
He's here present Judge at Maine.
Good morning, Mr. Day. You're before the court today for one count of robbery with a firearm, aggravated assault with a deadly weapon without intent to kill, and 3 burglary with assault or battery.
And, Your Honor, the state would be seeking a no bond hold on counts 1 and 3 upon a finding of proof evident or presumption great for first appearance purposes only. On count 2, Your Honor, I'd be requesting a $25,000 bond. Obviously, no victim contact, just based on my concerns on the allegations. Mr. Day unlawfully entered the property armed with a Mossberg shotgun that was recovered. While it was found unloaded, he did threaten to kill one of the victims on more than one occasion. On one occasion, pointing the firearm at the victim and racking the shotgun. On another occasion, having the victim held down on the ground on his knees and placing the shotgun to the back of his head.
We would object to the court making a finding of proof evident presumption great at this stage of the proceedings. That is the highest burden that we have in the criminal justice system, higher than proof beyond a reasonable doubt. All that's been submitted to the court today is a probable cause affidavit. The state has called no witnesses, introduced no evidence. Basically, this is a one word against another person's type of case, in which case that may be enough to get to a jury, it may not, depending on how things unravel. It's certainly not enough to establish proof evident presumption great and hold Mr. Day without bond, which is the most severe pretrial type of restriction. So we would ask the court at this point in time to deny the state's motion to establish proof evident presumption great. If that's what they want to do, they should work for it. They should bring in some witnesses. They should call some evidence. They should call some testimony, have some evidence. They haven't done any of those things. They're just handing the court a piece of paper and saying hold him without bond, and that's insufficient. I would ask the court to allow Mr. Day to post a bond on these charges. If over the defense objection the court does find proof evident presumption great, I'd ask the court to exercise its discretion and set bond for Mr. Day.
Okay, thank you. I've reviewed the probable cause affidavit, and I find probable cause for these counts. I also find that proof is evident. So I'm going to hold Mr. Day on counts 1 and 3, no bond. Mr. Day, that does not preclude you from your attorney filing a motion to set bond based on State v. Author. And as to count 2, I'll impose a $10,000 bond. Good luck, sir.
And Your Honor, just in abundance of caution, I request no victim contact.
And no victim contact, sir. With Norland Rocha or Cindy Perez. Good luck. Danny Custer.
He's approaching judges here at Maine.
Mr. Custer, good morning. Sir, you're before the court for 1 count of burglary of an unoccupied dwelling, unarmed, and 2 criminal mischief. The court does find probable cause. It says defense.
Judge, in speaking with Mr. Kuster, he advised me he's 66 years old. He came down here from Idaho. He's been here about 1.5 years now. Unfortunately, financially, he's going to be homeless, Judge. He's on a fixed income at Social Security. From what he advised me, there's really nobody that can help post a monetary bond. So we'd ask you to take that into consideration in determining reasonable release condition, and it's on behalf of Mr. Kuster.
And it also appears, Judge, that this was where he used to live, and I guess he just didn't have any place else to go. And it's been kind of cold out, so maybe that's where he figured he could best find refuge.
Based on the probable cause affidavit, that was apparent. So, Mr. Kuster, you cannot go back to this place unless you're paying rent or something. So what I will do, sir, is I will release you to standard pretrial release. And you need to make sure that you check for your court date so that you know when you have to come back to court, but no return to, no return to 470 Sunshine Drive, in Coconut Creek. Good luck, sir. Pretrial release, standard. Counselor, if you have a case on the docket, if you'll let the deputy know so we can find your paperwork.
Perfect, Judge. Thank you.
Isaiah Kendricks.
He's here present, Judge of Maine.
Mr. Kendricks, good morning. You're before the court today for 1 count of carjacking without a firearm or weapon. The court does find probable cause as the parties wish to be heard as to bond.
Your Honor, I'm going to be requesting a $20,000 bond, pretrial release of the GPS monitor on the first-degree felony. It looks like the defendant confessed to committing the offense. It alleges that he and his co-defendant made a determination even before following her into the parking lot that they were going to rob this woman of her vehicle. They knocked the woman to the ground, stood over her, choked her, demanding her keys. I am concerned about the level of violence, and I would just, if I just have one moment, Your Honor.
You can go ahead, Mr. Romero.
Thank you, Judge.
Yes, Judge. Mr. Kendricks is 18 years old. He's been living in our community his whole entire life. He is employed. He works at the American Airlines Arena in their cleaning maintenance department. He's been there for about 1 year, making $8.25 an hour. Judge, he lives in Davie with his girlfriend and his mother's girlfriend. My understanding is his mother's girlfriend kind of supports the household. She's a housekeeper by trade. So from what I've discerned from Mr. Kendrick's information, he's not in a position to post that monetary bond which the state is requesting. Most importantly, Judge, from what he advised me, and certainly the state's going to confirm this, Mr. Kendricks did advise me he has a clean record. Judge, we're going to be asking, I know these are serious allegations, so I'm not going to be asking for a straight pretrial or ROR. What I'm asking for is a $5,000 bond, something which maybe Mr. Kendrick's family can come up with, along with standard pretrial release so he could be supervised while he's outside waiting for a court date to come back and address these allegations. So that is the defense's request, Judge, $5,000 along with pretrial release.
Mr. Kendricks, when was the last time you went to work?
I think last month sometime because I just recently moved to Fort Lauderdale from Miami.
Okay. The court does find probable cause. As to count one, I am going to impose a bond of $10,000. If he's able to post the bond, he'll also be on a GPS monitor. Good luck, sir. Brian Salgado.
Judge, he has posted bond on count one.
Okay. Mr. Salgado, you're before the court today for one count of loitering and prowling, and count two is a violation of probation. The court does find probable cause, and I'm told that as to count one, your bond has been posted. You should be seeing your felony judge shortly on the violation of probation.
This violation is out of Miami-Dade?
Okay.
They'll take him to Dade County, Judge.
All right, thank you. Thank you. Anthony Estaba.
He's approaching, Judge, he's here, I mean. 17.
Good morning, sir. You're before the court today for aggravated battery.
Good morning, y'all.
Good morning. You're before the court for one count of aggravated battery causing bodily harm. The court does find probable cause. What does the parties wish to be heard as to bond?
Your Honor, just based on the allegations, I'm requesting a $10,000 bond, no victim contact. I would note Mr. Estaba does have priors out of the state of New York, aggravated unlicensed operation of a motor vehicle from 2009, assault in the second degree with intent to cause serious physical injury. He was sentenced to 18 months to 3 years in state prison.
Can you hold on just to Mr. Linder?
Of course.
Good morning. I'm just going to go off the record a little bit to speak to this children. You were in the middle of talking about Mr. Estaba?
Yes, he also had in the late 90s a felony drug prior out of New York that he was sentenced to state prison on.
Okay.
And his wife is present, Your Honor.
All right, good morning. How are you? All right, what, do you wish to address me in regards to his bond?
Yes.
Okay.
We have 6 children, and he is the only person that is taking care of the family right now. I'm actually studying to sit for the February bar, so I need him home, because he picks up the children from school, and he's the only one that works. So if they can reduce his bond, the priors that they're talking about are about over 17, 18 years ago. And I kind of just need him home so that I can finish studying for the bar and so that he can continue to take care of the family.
So what kind of bond do you think that you'll be able to afford?
I am not sure. I know $10,000 is really excessive. Even if it was $500, I would find it.
Okay.
Judge, and that's
yes.
basically what also be kind of asking for a bond reduction. As you heard, Mr. Estaba is the sole financial provider of the home. My understanding is that this incident, I believe it was where he worked. I did advise him on this type of offense. The court's going to order no contact, so he's not going to be able to have any sort of contact with the alleged victim. That's going to force Mr. Estaba now to look for other employment and quickly in order to support his household. As you heard, he has 5 children. They all go to public school, not private school. As you heard, one of the kids is actually in college. My understanding, judges, they rent. They do not own. They are on housing assistance, Section 8. They do own one vehicle, but it's a Dodge Journey 2012 with, I believe, over 100,000 miles on it. So therefore, they really have no sort of financial resources. Where I was going to be proposing, judges, $1,000 bond plus pre-trial. So that wise, his wife, using the services of bondsman, can you come up with the premium? But right now, as you heard, he's the one that basically takes the kids to work, picks them up from work while his wife is studying for the bar. So that's what the defense is going to be asking for at this time, Judge.
Thank you. Thank you, ma'am, for coming in. And I do understand, as you've explained, your financial situation, but also, you know, I have to balance the entire circumstances, and it's a bit concerning, the circumstances surrounding this aggravated assault. So I'm going to impose, I do find probable cause. I am going to impose a bond of $5,000, and he is also going to be on standard pretrial if he posts his bond. Good luck. Thank you.
Judge, can you sign an order allowing us to photograph the injuries Mr. Estaba sustained?
I will do that. Thank you.
Thank you, Judge.
And no contact, no, sir, no contact with the victim in this case. No contact.
It was at the job at work. I don't even know him.
Okay, we no contact.
Yes.
Okay. Counselor, what's your case?
If I may, Judge?
Yes.
Page 9. Last name is Santiago. First name Jose.
Oh.
I just received a call. I was down in the library.
Okay.
So I appreciate getting a call.
All right. All right. Jose Santiago. He was here before. Mr. Santiago?
What page did you so I could look at my
Page
board?
9.
Page 9.
He was
I
up
believe
before,
he is,
and we recalled.
North Broward.
Okay.
North Broward, Your Honor. We thought you were done with him. He went back.
No, we put him on recall because his attorney wasn't here.
Okay, we'll get him back.
All right.
I'll take a seat, Judge, if that's okay.
Okay, thank you.
Thank you, Your Honor.
Okay.
Antoine Dwayne Jones.
Oh, I believe that's a medical reset, Judge.
Antoine Jones is a medical reset.
Yes.
John Michael Tetty.
Judge,
Your Honor,
Mr.
Lawrence
Teddy
Wolk
advises.
was the attorney on Mr. Teddy's case. He would like to appear by phone.
Who is the attorney?
Lawrence Wolk.
Okay,
And I have his number whenever you're ready.
all right.
It's 954 445 8850.
Your call has been forwarded to an automatic voice message system. 954.
Four 8850, right? That's what I dialed.
Mr. Wolk is in Henry County. He's probably in the courtroom over there now. His assistant is going to be contacting him, and he's going to contact me when he's done with court. So if we could place Mr. Teddy on recall at this point until when Mr. Wolk becomes available.
Mr. Teddy will recall you. We're trying to contact your attorney.
Yes, thank
You
you.
can have a
Your
seat.
Honor.
John Paul.
Judge, he's here present, and he declined the service of public defender. He is proceeding pro se.
Good morning, Your Honor.
Good morning, Mr. Paul.
Yes, Your
Sir,
Honor.
sir, don't, please.
I understand I cannot speak of the facts of the basis of the case, Your Honor.
Okay, Mr. Paul.
Yes, ma'am.
I'm going to need you to listen, okay? All right.
I'm listening.
I need to make sure that you understand what you're doing today, because you're facing serious charges. Do you not wish to speak to the public defender's office so that they can help you through this stage of the proceedings?
No, ma'am, Your Honor. I've been through it
Okay,
before.
Mr. Paul, you're going to answer a yes or no to each question. Don't keep talking. All right. Do you plan on hiring a private attorney?
No, ma'am.
All right. Then, Mr. Paul, you are before the court today for 1 count of possession of cocaine, 2, possession of MDMA, 3, possession of cannabis 20 grams or less, 4, tampering in a first-degree felony proceeding, and 5 is a traffic capias. All right.
Yes, ma'am.
You
May I
need
speak?
to, not yet. Go ahead,
All
sir.
right. Thank you, Your Honor. I guess dealing with the easier part first. Your Honor, I provided the court with a supplement, an additional PC affidavit, specifically for counts 1 and 3. In the original PC, it didn't mention that the cocaine and cannabis were field tested. The report I provided to the court does reflect that. Your Honor, moving on to count 7. Your Honor, I'm going to be seeking a no bond hold on that count. I understand that Judge Coleman said a $100,000 bond on the arrest warrant. However, tampering in a first-degree proceeding, in this instance an armed robbery firearm, is a punishable by life offense. I can tell you the defendant in that case, the armed robbery that is referred to in the affidavit, he has been charged with armed robbery. He is being held no bond. Ms. Michelle, who's referenced in the affidavit, she was picked up, arrested for tampering in a first-degree proceeding, and she's being held no bond. I would note the evidence in this case is that Mr. Paul approached the victim of that armed robbery case and
Alleged, sir.
violently threatened him, advising him that he is the defendant's brother and that he has relatives that want to blow the victim's head off. I would note that Mr. Paul was identified by both, not only the victim in the case, but Kathleen Michelle also identified him as the suspect that physically threatened the victim in her presence.
Whenever you're ready, ma'am, I would like to speak.
Okay, sir, you can go ahead.
Okay, first off, I would like to go at counts 1, 2, and 3. All right, that happened yesterday. That's a fresh case. The officer, when we was on the scene, he read out everything for the search warrants, everything. The search warrant, I don't know if you have it in front of you, it stated that they have a search warrant for every vehicle in that, at that address, ma'am. My vehicle is not registered to that address. True to do, it was there. I know we're not here for the facts of the basis. And I'm all right with the bonds anyways with them, you know, but I still want to speak on record that, first off, the search warrant claims that the vehicles that stays to that address, my vehicle does not stay to that address, which they went in there without my right to search it. But, you know, they say they had a search warrant. I'm not arguing that. Second off, the search warrant states January 23rd, Sunday. That's when they were supposed to serve it. They served it yesterday, January 31st, ma'am. You know, I strongly disagree. I feel like the search warrant is bogus. But counts for tampering with in a first degree felony. The word tampering is a very broad word, ma'am. So what I would say with that is, just like the other proceeding that was brought before here today, the state attorney did not bring any witnesses. Everything that's being said right now is hearsay, ma'am. They say the state attorney himself just said the Michelle, who is also being charged with tampering. Ma'am, I'm not being charged with robbing anybody. I don't even know the man who they're saying is my brother.
Okay, Mr. Paul, when you start getting into the case, I'm going to advise you to stop.
I'm just replying to what the state said. I'm just replying to they said it.
I'm going to advise you to stop talking about the case. Okay?
Okay, I'm not going to.
Sir.
This is my only request.
Yes.
I only have one. My only request, ma'am, is just can the state please give me a makeable bond? $100,000 bond is a very, you know, outrageous bond. I had no money. I'm in school right now for aviation. And I own my own company that's been open since 2015. I have no violent offenses on my account. I only have one conviction, and that's possession of a firearm by a convicted felon, which is not violence. It was just a possession. I'm just asking for a makeable bond on count 4, ma'am. You know, $100,000 is very excessive.
All right.
I don't know none of these people, you know. I was just brought this. I haven't seen no officer. I wasn't put in no lineup. Everything is really spectator.
All right, Mr. Paul. The court does find probable cause as to all the counts. On count 1, your bond is $1,000. Count 2, $1,000. Count 3, $100. Count 4, the state's asking for no bond. I'll leave the bond at $100,000. And then the KPS, the KPS matter, the bond is $250. Mr. Paul, my records do indicate that you should be going to your felony judge on February 4th at 8:30. And I suspect you'll be able to make any motions that you want to at that time. Good luck, sir.
Your Honor, I would be requesting now.
I would like to verbally just say that I would like an evidentiary hearing for what's going on, because no evidence been brought to me.
Well, that's why you need an attorney, or you need to file a motion.
I understand.
I'm sorry. Don't go anywhere, sir. Just wait a minute.
Your Honor, on the tampering, I was just going to request an order of no victim contact.
And Mr. Paul, at this time, like you said, allegedly, no contact with the alleged victim.
I understand.
Okay, good luck, sir.
Thank you, Judge.
Timothy Mack.
Mr. Mack is approaching, Judge, here at Maine.
Mr. Mack, you're before the court for distribution or delivery of cocaine. The court does find probable cause. Does Mr. Mack have prior drug priors?
One moment, Judge. I show no criminal history, Judge.
All right.
Judge, if the court, based on the fact that he has no priors, we're going to be asking the court to consider an ROR on his behalf. If the court's not inclined to do a straight ROR, then we're going to ask the court to leave the bond in place.
Okay, then the bond will be left in place. Good luck, sir. John William Holmes.
Mr. Holmes is here present. Judge Amain, approaching. Come on up, sir.
Mr. Holmes, good morning. You're before the court on 3 counts of distributing or delivering cocaine, and the court does find probable cause. Does Mr. Holmes have priors?
Your Honor, I'm checking to see if he has priors elsewhere. Out of Broward, DUIs in 2011 and 07. I don't have the ability to check if he has priors elsewhere at this time.
Okay.
Nothing to add from the defense, Judge.
Okay. As to counts 1, 2, and 3, the court does find probable cause, and I'll impose a bond of $1,000 on each count. Good luck, sir. Joe Davis.
Mr. Davis is here present. Judge Amain, he's coming up.
Mr. Walk is waiting.
Oh, okay, thanks. Mr. Davis, good morning. Sir, you're before the court today on 2 counts of distributing or delivering cocaine and 1 count of possession of cannabis 20 grams or less. The court does find probable cause. Does Mr. Davis have any priors?
Yes, Your Honor, one moment. Let's see. I'm getting hits out of North Carolina, California, New York, and Georgia. Out of New York, 2008, criminal facilitation, criminal possession controlled substance with intent, criminal possession controlled substance. Out of Georgia, (2016), he was extradited from Florida to Georgia on a parole violation, sentenced to 2 years state prison. In looks like his priors out of Georgia are drug-related, transactional. I see multiple failures to appear. Out of Broward, while dated, he does have drug priors going back to from the late 90s to the early 90s for possession charges where he was sentenced to state prison.
Okay. The court does find probable cause, and the bonds on count 1 and counts 1 and 2 are $2,500, and the bond on count 3 will remain at $100. Good luck, sir. Then Mr. Wolk is available on the Teti case. I'll recall John Michael Teddy, and I'll be calling his attorney.
Hello?
Good morning. May I speak to Mr. Wolk?
That's a T.
Mr. Wolk, this is Judge Jackie Powell. I'm calling from First Appearance Court.
Hey, Judge, how you doing?
I am doing well. Sir, I just need to advise you that you're on speaker and we are in open court.
Yes, ma'am. I'm over in court in Henry County right now.
All right. I appreciate you appearing by phone. Appearing by CCTV is John Michael Teti, and I have been informed that you are his attorney.
That's correct.
All right. Well, we're going to go ahead. Mr. Teti, you're before the court today for one count of authority figure soliciting or engaging in romantic relationship with students. The court does find probable cause as to that count, and does the parties wish to be heard in regards to the bond?
Yes, Your Honor. Eric Linder.
Okay, Mr. Wolk?
Yes, sir.
The state's gonna go first, and then I'll let you go next. All right. Okay.
Thank you, Judge. Eric Linder on behalf of the state. Your Honor, I'm going to be requesting a $50,000 bond, pretrial release with a GPS monitor, no contact with the alleged victim JL, no contact with minors. Your Honor, I believe this bond and these conditions are necessary to ensure not only that Mr. Teddy will have no communication with the victim in this case, but not have inappropriate communications with any minors. Your Honor, I would note, and I believe they're necessary because, as noted in the probable cause affidavit, Mr. Teddy received an internal reprimand from the school in October of last year regarding having inappropriate communication with students. He continued to have
I can't hear. I can't hear Eric. I can't hear.
All right, Your Honor, I'm requesting a $50,000 bond, GPS monitor, level 2, no victim contact, no contact with no contact with minors. I believe the bond and these conditions are necessary to ensure the safety of the victim in this case. Mr. Teddy already received an internal reprimand from the school in October of last year regarding inappropriate communications with students. Despite that reprimand, he continued to have inappropriate communications targeting this victim. At a later date, he was confronted by the victim's father about these communications with his daughter, and he continued to communicate with the victim. And I'm even more concerned, Your Honor, I'm looking at Mr. Teddy, he's rolling his eyes. I don't believe he takes this very seriously at all, and I have great concerns. Your Honor, I'm having concerns now, even with the $50,000 bond, that he will follow any orders from the court to cease having communications with his victim.
Okay, Mr. Wolk?
Mr. T is 40 years old. He's got no prior criminal, what I understand. It is reasonable bond, somewhere around $7,500.
Mr. Wolk, I know you're probably on a cell phone. It's going in and out. So what I heard was that you were asking for a $7,500 bond. Is that correct?
That's $7,500.
Okay. All right. Do you have anything else,
He's got no prior criminal history, Judge. There are some psychological issues that are being addressed in the family, but other than that, Judge, they've been a pretty citizen. This is one matter that we'll deal with, but he trusts him a good family, a good home. He's not a big risk. I don't have any problem. He has a passport, but he's the second degree. It should be somewhere around $7,500 with all the special.
Okay, thank you.
That's the financial resource.
All right, Mr. Wolk, thank you very much. Can you hear me, sir? I want to make sure that you're hearing me.
Yes, Your Honor.
No, Mr. Wolk, your attorney. Mr. Wolk?
Yeah.
Okay. Okay, thank you, counselors. Mr. Teddy, you're before the court, as I indicated, and the court does find probable cause. There's also great concerns for the community, and with that in mind, I am going to set your bond, sir, at $50,000, and if you're able to post that bond, you'll be on a GPS monitor. No contact with the victim with the initials JL, and also no contact with any minors. Good luck, sir.
Thank you, Your Honor.
One moment. Go ahead, Mr. Linder.
Thank you, Judge. Just to be clear, so there's no confusion, if the court could clarify to Mr. Teddy, when you advising no contact, that means by any means, electronically, in person?
Oh, okay. All right. Mr. Wolk, are you speaking? Because, again, you're going in and out. What are you saying, sir? Hello? All right. Mr. Teddy, I don't know if your attorney is hearing me because now I can't. I've lost contact with him. But no contact means not by phone, not by internet, not by text, not by any social media. No contact. Okay. Good luck, sir.
Thank you, Your Honor.
Your Honor, I'm advised that North Broward has Mr. Santiago back.
Okay.
Thank you.
And yes. Santiago at North Broward. All right, Mr. Santiago. Sorry for the delay. Counselor, I did find probable cause before, and your attorney, did I? I find probable cause. Do you want to make an argument as to the bond?
If I may, Judge, as it relates to the bond, we actually, I think, have a stipulation. So I've spoken with the state. The state is aware of his record with regards to the pending allegation as it relates to the Diaz case and prior that he has, I think, from 2013. The stipulation is, as it relates to the two counts, it's going to be $2,500 on one, $2,500 on the other, and pretrial. Am I correct?
That and just a TAD monitor.
And certainly a TAD or scram monitor.
All right. So, Mr. Santiago, I do find probable cause, and based on the agreement between your attorney and the state, the bonds on each count, $2,500, and you'll be on a TAD monitor as well. Okay?
Can you ask Mr. Santiago? I understand I believe he understands English. Can you make sure he understands everything that was said, Judge?
Mr. Santiago, do you understand?
Yes, ma'am.
All right. And do you understand how much the bond is?
2,500 for each one.
Okay. And then they'll also put there's an alcohol monitor that you're going to be on until further order of the court. Okay?
No problem.
Mr. Santiago, can you do me a favor? Just call my office upon your release, okay? And if you if you need somebody else to contact my office, please do it immediately, and don't say anything else, please.
Okay, thank you, sir.
Thank you.
All
Judge,
right.
thanks for your time. I appreciate
You're welcome. I'm gonna go off just a little bit again because I have some. Roosevelt Rivers.
Oh, Your Honor, Mr. Reedy stepped out for a minute.
Oh.
He had to use the facilities.
We're going to put on brief recall.
Well, it's Mr. Reedy that stepped out, so Mr. Romero, do you want to handle it, or?
Judge, I know if it was a warrant, probable cause doesn't really need to be determined at the the police report.
Right.
But count one, new law offense, so I would want to wait for Mr. Reedy.
Okay.
Do you have any children? Do you have questions on heart?
All right, Roosevelt Rivers.
He's here at me.
Mr. Rivers, good morning. Sir, you're before the court for one count of grand theft, and then counts 2, 3, and 4, which are not for magistrate, are felony VOP. The court does find probable cause as to the grand theft, and Mr. Rivers is being held no bond on the other 3 counts. The bond on count 1 will remain at $1,000, and my notes indicate that he should be going to his felony division judge on February 4th at 8:30. Good luck, sir. Eugene Lumsden.
He's here present, Judge.
Your Honor, if I could be heard before the court makes any determination.
Sure.
I checked his record. He does not qualify as a
convicted
violent career criminal. So I have no objection.
So number 5.
4 and 5.
4 and 5.
So I have no objection, no PC on those counts.
All right, but, Madam Clerk, you'll tell me, there's discussions back and forth over whether I should put notes on or put a line through. Do you want me to do that?
On the second part of the findings and order, Judge?
Yes.
I'm about to say it's no PC?
Yeah.
It's no PC?
Right,
On
so
4.
you just want me to write it there, okay.
And then next to that, you will put the counts, 4 and 5.
All right.
And the other ones, you will check the top box.
In other words, don't put any writings on my PC. I get it. Mr. Lumsden, Mr. Lumsden, you're before the court today. Presented were count 1, grand theft, 2, possession of a weapon or ammo by a convicted felon, 3 is the same thing, 4 and 5 are possession of weapon by a violent career criminal, 5 is distribution to or deliver cocaine, 7 distribution or deliver cocaine, 8 resisting officer without violence. As to counts 1, 2, 3, 6, 7, and 8, the court finds probable cause. As to counts 4 and 5, there's no probable cause, and the court will leave the bonds in place on count 1. On count 2, I'll impose a bond of $1,000. On count 3, $1,000. 6 will remain at 25, 7 will remain at 25, and 8 will remain at 100. Good luck, sir.
Judge, you got 9, 10, 11, and 12.
Parole violation, that's a no bond hold. You should be going before the parole board soon. 10, the bond for possession with intent to sell or manufacture, deliver cocaine, the bond will remain at $2,500. The possession of drug paraphernalia, 100. And 12 is also another violation of parole. You should be going before your parole board shortly.
Judge, our only request is going to be, would you sign an order allowing us to photograph the injuries Mr. Lumsden sustained?
I will. And so the court does find probable cause on counts 9, 10, 11, and 12 as well.
And the ones that found no PC, Judge, on 4 and 5 want to be all R.
Yeah, I'm not requesting any time on those.
Okay.
Thank
Okay. 4 and 5. No. Probable cause. Okay. Quantrell Stokes.
He's here, President Judge Maine.
Mr. Stokes, good morning. There are 4 counts of 3 misdemeanor capias and 1 felony capias. Count 4 is not for magistrate. Counts 1, 2, and 3, I'll leave the bonds in place. Good luck, sir.
Thank you, Judge.
Kenlor Chevalon.
Mr. Chevalon, come on up, please.
Mr. Chevalon, you've got a 1 count of violation of probation, and then there's a felony capias. The court does find probable cause. Both those are no bond holds. My notes indicate that you should be going to court February 4th at 8:30. Good luck, sir. Chad Siskind. Mr. Siskind, you're before the court today for 1 count of grand theft. The court does find probable cause. Does Mr. Siskind have any priors?
One moment, Judge. I don't have anything on him. I do have concerns about ties to the community. The booking shows at large, and the PC affidavit shows a Missouri address.
Judge, from my understanding, Mr. Siskind basically has a clean record, maybe 1 misdemeanor petty theft that he believes may have been dropped or something like that, but he has basically no prior felony offenses. He is from St. Louis. He's relocated down here. He's now been living here in South Florida for about 4 months, Judge. He's 34 years old. Oh, 24, I'm sorry. He's 24 years old, Judge. He lives with his aunt in Deerfield Beach. His aunt, from what he informed me, is on disability, so she doesn't have the money to post his monetary bond. We're going to be asking the court to consider releasing him on pretrial release.
What is the address? Where do you live?
1725 Northeast 8th Avenue in Deerfield Beach. I'm not sure of the zip code. Apartment 104.
Okay. I will release Mr. Siskind to a standard pretrial supervision. And in the meantime, Mr. Siskind, no return to that Tasty Joint smoke shop. Do you understand that, sir?
Yes, I do.
You're being handed the directions for pretrial release. You need to report within 24 hours of your release. I understand that today's Friday, so on Monday, because they're not open on the weekends. If you fail to report, you will be arrested.
Yes, sir.
Okay, good luck, sir.
Thank you, Your Honor.
Derek Roundtree.
Judge Derek Roundtree was sent to the division. Those are VOPs.
Okay, so then we don't need to reset him here. Mr. Roundtree was sent to his division, Judge.
Yeah.
Right. Nicholas Garcia.
Mr. Garcia is here present, Judge at Maine. He's approaching.
Mr.
Good morning, Your Honor.
Good morning, sir. You're before the court for 1 count of robbery with a firearm, 2 aggravated assault with a deadly weapon without intent to kill, and 3 burglary with assault or battery.
And, Your Honor, I'm going to be asking that the court make the same findings that you made for his co-defendant earlier. Proof evident and presumption grade on counts 1 and 3, $10,000 bond on count 2, no victim contact. The allegations are, in this case, Mr. Garcia stole one of the victim's cell phones. He also placed one of the victims in a chokehold. One moment. He began to strangle the second victim by placing his arm around her throat and a hand over her mouth while commanding her to stop screaming.
And we would make the same argument, Judge, that we made on behalf of Mr. Garcia's co-defendant earlier this morning.
Thank you, counselors. The court does find probable cause. I do find probable cause on all 3 counts. And I do find that proof is evident as to counts 1 and 3. And the court will not impose a bond at this time. Mr. Garcia, you too will be able to go to your division judge for an Arthur hearing. So your attorneys can file a motion in regards to the bond in your division. And as to count 2, I will set a bond at $10,000. And I'm also ordering you not to have any contact with the victims in this case, Norlin Rocha or Cindy Perez. Good luck, sir.
Judge, we're going to be requesting a photo order.
And I will sign an order for photo. DeMarcus Bellany.
Approaching, Judge.
Good morning, Mr. Bellany. Sir, you're before the court for 1 count of grand theft, 2, possession of cannabis 20 grams or less, and 3, possession of blank or fictitious unlawfully issued driver's license. The court does find probable cause. Okay. Does Mr. Bellany have any priors?
I'm pulling that right now, Judge.
And Judge, while we wait on that information, the defense is going to be requesting a straight ROR. He's 20 years old, been here his whole entire life. He graduated from Piper High School as of 2017. He's saving up to go to college. Unfortunately, he lost his job. He was working at Toyota Financial Services, customer service, making about $11.50 an hour. He's helping out his mom, who he has a younger brother with a mental illness that he helps with, and he lives in Sunrise. And his mother works in a local school in their cafeteria. Judge, because I believe, hopefully, the state will confirm he has a clean record, I'm going to be asking for the court to consider releasing him ROR on these offenses, Judge.
Yeah, I see no adult record, Your Honor.
Okay. Mr. Bellany, when was the last time you worked?
December 22nd.
Of 2000 and when?
18.
Okay. All right. I will not ROR Mr. Bellany, but I will release him to standard pretrial release.
Is that 1 moment, Judge? 1 moment.
Okay.
Judge, respectfully, at this time, the only thing then we'd be asking you, if the court's not inclined to a straight ROR, to leave the monetary bonds in place. However, on count 2, which is the misdemeanor cannabis, I would want the court to consider it just an ROR on the cannabis. I don't think the state would have an ROR on the cannabis.
Okay, then I'll do that. $1,000 on one, $1,000 on three, and ROR on two. Good luck, sir.
Thank you so much. I'll call your girlfriend and your uncle, okay?
Bobby Farmer.
Mr. Farmer, come on up, please.
Mr. Farmer, good morning. Sir, you're before the court for grand theft, and the court does find probable cause, but I've also been told that your bond has been posted. Good luck, sir.
Good luck, sir.
Gayron Lamar Garrett.
Mr. Garrett is approaching, Judge.
His bond has been posted also.
Mr. Garrett, good morning. You're before the court today for possession with intent to sell or manufacture or deliver cannabis and possession of an open container, which is not for magistrate. Sir, I do find probable cause, but I've also been advised that your bond also has been posted. Good luck, sir. Tyler Paul Otto.
Mr. Otto is here present, Judge. Amain approaching.
Mr. Otto, good morning. You're before the court for possession of THC and not for magistrate, unlawful speed, and taillights, improper taillights. The court does find probable cause. Your bond is $1,000, and I'm inclined to leave it there. Good luck, sir.
Judge,
yes.
I'm first going to be asking if the state has an objection to a straight ROR. My understanding, Judge, is he has a clean record. He's 18 years old, been living in our community his whole entire life. He is a senior. He's currently attending Coral Springs Charter High School, in which he has a weighted GPA of a 3.7 and an unweighted GPA of 2.8. He just took the SAT, scored a 1270. He's already gotten accepted into 2 schools, UNF and Florida Technical, but he's still waiting to hear from UCF, and that's where he wants to go to school in order to be an aerospace engineer. Besides going to school full-time, Judge, he is working. He works at Deja Blue Restaurant, where he's a dishwasher, and he's been there about 4 months. He does also volunteer in the community. He volunteers at the Sawgrass Nature Center, which is a wildlife rehabilitation facility in which he cleans out the cages, Judge. If the state will confirm he has a clean record, Judge, there's a release on non-monetary conditions. Judge, I'm going to be asking the court to really consider releasing Mr. Otto on this possession of THC on a straight ROR. He's not a flight risk. He's going to be coming back for it. That's what we're asking for. If the alternative, if Your Honor does say pretrial, we're respectfully going to be denying it. He gave me the phone number. I'm going to call his mom. Hopefully by the mom contacts the bondsman. Bondsman comes over here. I mean, he could probably be in jail and probably another 12 or so hours or more. I don't want him to go through that. That is why I'm asking, Your Honor, to really consider a straight ROR on his behalf.
Also, Judge, this appears to be a residue case, which may very well end up being filed only as a misdemeanor rather than a felony. I think the court can take that into consideration when discussing or ruling on Mr. Romero's request.
Okay. Then I'll grant the ROR at this time. Mr. Otto, you need to make sure that you check your mail, know when you have to come back to court. Okay? Good luck, sir.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Scott Vandermark.
Mr. Vandermark is here present, Judge.
How you doing, Your Honor?
I'm doing well, Mr. Vandermark. Sir, you're before the court today for 1 count of possession of oxycodone and a possession of cocaine. The court does find probable cause.
Judge, my understanding is, and the state will verify this, he's he's been arrested. He's a registered voter here in Broward County. He works. He lives in Pompano Beach, where he rents an apartment where he's been staying at for 7 years. He's college educated. He did give me the phone number of his mother. However, I'm going to be asking the court to consider a straight ROR. These are nonviolent offenses, and most importantly, he's going to be coming back to court And hopefully the state will verify he has a clean record. So I'm going to be asking for a straight ROR on Mr. Vandermark's behalf.
Do we have any priors on Mr. Vandermark?
Pulling that right now.
Mr. Vandermark, while the state's looking for your record, are you employed? I don't remember if you're...
Yes, I am. Broward County Schools. I coach. I do the summer program at South Broward High School. I'm a full-time substitute. I'm looking for a full-time position, but I'm a full-time sub at Deerfield Beach Middle School.
I'm showing no priors, Your Honor.
Okay. Okay, the court does find probable cause, and I will release Mr. Vandermark to standard pretrial supervision with random testing.
Judge, one moment, please. Judge, respectfully, my understanding is I believe he was stopped in his vehicle. He just finished dropping off 3 other occupants. That's going to come out at a later date, and I hopefully, once the case filer gets that information, this will ultimately be dropped. Like I said, Judge, respectfully, if the court is not inclined for a straight ROR, considering he has no prior record, he's going to be coming back to court, he's a registered voter, then we're going to respectfully deny his standard pretrial, and I'll call his mother to post his bond. But I'd ask the court to reconsider a straight ROR on Mr. Vandermark's behalf.
Thank you, Mr. Romero. At this time, I'm not going to grant a straight ROR, so the bonds will remain in place at $1,000 each count. Good luck, sir. Alex Beltran.
North Broward, Your Honor, and Mr. Beltran is a medical reset.
Okay, thank you very much, Deputy.
You're welcome.
David Gray.
North Broward, Your Honor, and David Gray refused.
And, Your Honor, I would just request if the court could keep the bond at $750.
No objection. Mr. Gray represented by the public defender's office?
We do, Judge. We don't object.
All right, then I'll find probable cause, and the bond will remain at $750. And then Shane Dukes.
North Broward, Your Honor, he also refused.
And the state make the same request.
Is he represented by the PDs?
Your Honor, we don't object.
Yes?
Yes.
Yes?
Yes,
okay.
And a $1,000 bond is
all right, acceptable. The court finds probable cause, and the bond is $1,000. Thank you, Deputy.
You're welcome.
Yes, thank you, Deputy.
All right, I believe that we're at the end of our morning docket. I'll see everyone this afternoon. Thank you.